Well, good evening, everybody. How's everybody doing?
Good.
Well,
How are you?
I'm excited to be here. I was giggling, but I got myself under control. How sad is it? This is a highlight of my day, highlight of my week, highlight of my life to get to come see y'all folks, even if it's just on video. Great day. What a boring life I lead. Oh, it's good to see everybody tonight. What are we going to have for breakfast when we get together? We get together in a couple of weeks. Our next time together, we're going to meet in person, and we said we'd do breakfast. What are we going to do? Courtney said she wanted scones. I don't know. Y'all want biscuits? You want scones? What do you want?
I would say biscuits. I mean,
Biscuits. All right.
so
I'll
I'll
do
go
a
with
little.
biscuits.
I'll do a little quick survey for Bojangles then. That sounds good to me. It's easy. I'll do that. I've always done Bojangles biscuits, so I'll do that. We'll have those. What, on Saturday morning? Or we won't have them Saturday morning, or we won't have them Sunday morning.
Saturday. I feel like I'm
Saturday.
making the decision.
All right,
All right.
Bojangles Saturday. Got it. And I'll get the survey out Saturday. Okay. Laura shared an article with me this week about Gaston County wants to make their school board races partisan. Laura, you want to catch us up on what's going on with that?
Well, yeah, it was on the news, and then I read the article as well, and it was just stating that we have one of our representatives who would like to now make our school board elections partisan, where they're sharing their parties, so that
Yeah.
so I guess people who are voting can be more informed about who they're voting for. It's just ironic to me because our school board already kind of looks a certain way and
Well, I mean, they might as well just paint a big R or a big L on them.
yeah,
Yeah.
already. So yeah, it was quite interesting because we had talked about that in class
Yeah. Yeah.
and
Now
now it's
that would require a policy change. Right now, that can't happen. So that would happen to happen. But with the supermajority in the legislature, if they want it to happen, it'll happen. But I mean, we have politicized the school board to the point where it is now a legitimate jumping off point to start a political career. And this just further solidifies that whole notion that we're no longer if we when we do that we are no longer educational, we're just a political organization now, but this will just make it out and just be out for everybody to see. um, yeah, that's another sad day for public education, that we continue to politicize what we do. um, Two or three things just kind of at random. I'm wearing a glove on my hand. I've got a skimp place on my finger and I bleed over and everything. I have to remind myself to wear a glove. Um, Dissertations. I hope everybody's just doing well. Take advantage of those times. Carter's going to meet with me tomorrow night. Take advantage of the times and let's talk through things. I'm seeing a lot of stuff that gives me concern. Um, I got a completed dissertation last night, and they said I'm doing a mixed methodology, and I was like, yeah, but which one? And I mean, wrote the whole dissertation and did not know which of the mix that they were using. That's a problem. If you don't know which mix you're using, how do you know what data to collect, what order to collect it, and what you're collecting it for? And then more importantly, you don't know how to analyze it if you don't know which of the mix you're using. There's four different ones. They do things completely different. You need to know again. I don't know. I mean, I would thought that everybody would know, but I have one that wrote a whole dissertation and didn't know that mixed is not it's not a research methodology. It is a family of methodologies, and you have to pick one and be consistent. She was not consistent in hers, and it's not gonna get through this semester. It's the first time I've seen it, but it's not going to get through. Her analysis is not done correctly. It's a parallel convergent. Parallel convergent means is both data have to tell us the same story. She thought she could just talk about one and then the other. No, do they tell us the same story? That's the whole point of a convergent design is you collect the same data but two different ways for reliability purposes. And that leads me to my next rant. If I hear one more person use the terms validity and reliability interchangeably or incorrectly, I'm going to strangle somebody. Validity only speaks to the instrument. Reliability speaks to the data that it produces. Is it real or not? Can we believe it? That's two different things. And I can't say enough. I don't need to read again that because I used a valid instrument, my data is automatically reliable. That is not true. That is not true. The whole point of chapter 4 is showing that your data is reliable. And then here's what I found. What you do with it's in chapter 5. But I don't know. It seems like that's pretty basic stuff, but I'm seeing a lot of issues with that. Now, literature review. You would be smart to summarize your literature review for themes because we're going to have to match those in 4 if you're doing any qualitative work. And in your literature review, make sure in your conceptual framework or theoretical framework section, and again, know the difference. There's theoretical is 1, conceptual is 2. You not only need literature from that person, let's say it's, I don't know, we'll just use Hertzberg as we always do. Or we could use any of the others, the social cognitive people, Bruner or Piaget or Vygotsky or Bandura or any of those, the social cognitive people. In your theoretical or conceptual framework section in chapter 2, you should have studies. You should have studies or research studies or dissertation that also use your same theorists. So that you won't just say Hertzberg 59, Hertzberg 59 1,000 times. But where that's really going to help you is when you circle back to your theoretical or conceptual framework in chapter 5 and you make a recommendation, you can show a link to a reference that says this is what we ought to be recommending. Every reference you make, every recommendation you make in chapter 5 has to link back to your theoretical or conceptual framework. Every one. All your themes in chapter 4 have to link back to the themes present in your literature review. That's what 4 and 5 are about. 4 is showing that your data is real, and 5 is that you didn't just do all this work and then just go off on a tangent and make whatever recommendations you felt like. That there's a theoretical basis for the recommendations that you make. It can't just be your opinion. Just like that S&S section, statement of the problem, need for the study, significance of the study in chapter 1 has to be well referenced so that it's not just you're some crackpot that thinks that this is a problem and nobody else does. You got to work on that piece. It's all in that literature. It's all in the literature. Those are the common things that I'm seeing. Everybody in the spring gets in a rush and we get a lot of people trying to finish at the end of any particular semester. Spring's always the worst. And so these are things that we just won't let you through. I mean, I can show you. It just won't get through. Students say, well, I don't know about all that. That seems like it'd take a long time. That's a lot of work. Yes, yes, yes. Let's try it. No, no, no. you got to do the work. I mean, I can't be more clear in that you've got to do the work, and these are things that everybody's dissertation is going to have to go through. Yes, it's rooted more in curriculum than I like as a leadership, as an LS person, but that's the tune. That's what we're going to march to. And so that's what we're going to do. Remembering that in chapter 4, you answer, you present your data by research question. You answer the questions with your data. Once you show that it's reliable, then you answer the questions. We've been having a lot of problem with that lately. And so those are some of the things that I'm seeing. Before long, I will put out a spreadsheet for summer. I won't take a break between spring and summer sessions. I'll have sessions right on through. That would be a wonderful time to catch up before diving into summer. And you know that your last class is coming up, and then you're going to be out there. You need, it'll be here before you know it. And here's the bad news. You do 1 year in dissertation, you have two in coursework and one in dissertation. When you continue past that, it's a 3 credit hour course every semester. That's another what, $2,000 every semester that you're in dissertation, beyond what you would normally expect to pay. That's a lot of money to me. So you can really get a lot done in May. You can make a lot of headway with nothing else to have to do. I know that's a bad time in school, but that's a good time. And this summer, and then you'll have the whole month of August, pretty much, before anything. But you don't have a lot of requirements in dissertation anyway. But you'll have the whole month of August. So I encourage you to get after it. All right. So tonight, let's look at our weekly schedule. Quit being crazy old man out shouting at clouds, and we'll look at the schedule. All right. So this is Tuesday, the 18th of March. We have Essex chapter 7. And we'll look at that in a minute. So that's where we are. We meet on the 29th and 30th in Charlotte. Then we have the makeup residency weekend. I'll be there April 5th and 6th. And then we have 3 more home Zooms. And then I have a makeup if somebody needs to make up a Zoom. Right now, I don't have anybody I think that needs to do a makeup. I think we're okay. But that's, again, make sure you see that that's what we have to do. Let me move to my other one for tonight. Tonight's presentation is Essex chapter 7. Courtney's got that, and then Alicia's got FERPA tonight. And so without further ado, and also Amanda, you might want to be on backup for chapter 10. If we have time tonight, we might even could knock that one out. If not, we won't worry about it.
Great.
Okay.
I have it ready.
I know you do. I've already graded it. I already looked at it. I was very impressed. It's almost like I do this for a living. All right, I'll stop my share. And we'll let Raven do her share. Let me turn my camera off to help her do her share. Oh, I gave y'all's names to a lady that I work with. I hope she contacted you. Her name is Sherry Aldridge. She's a new assistant professor in the College of Ed. She's doing some research. And I told her this particular group that y'all were just dynamite. And she wanted to talk to some of y'all. Seriously, she wanted to talk to some really sharp people. So I gave her your name. So hopefully Sherry will reach out to you. So that's legitimate.
Okay. Can everyone see that?
Yep.
Where'd it go? Okay, there we go. Okay, so Essex Chapter 7, Liability and Student Records. So This chapter discussed about educational records versus directory information, and then the laws and rights that went with it. So the educational records might include counseling information, program development, individualized instruction, grade placement, college admissions, whereas directory information is more about family background, disciplinary records. I misspelled that. I'll fix that later. But health records, progress reports, achievement tests, results. Definitely misspelled that too. Psychological data. The directory information may also include, we'll have like the name, the address, telephone number, date and place of birth, participation in extracurricular activities, weight, height, and membership on athletic teams, dates of attendance, diploma, and awards received. If parents object to this information being released, then it must be noted and it must be honored. The laws and rights is around FERPA, the Family Educational Rights and Privacy Act. The Buckley Amendment was enacted in Congress in 1974, and this guarantees parents and students some confidentiality and fundamental fairness to the use of student records. Once the student is 18 years old or attends a post-secondary institution, then the parental consent is not needed. Another part from FERPA was talking about if the information is not shared with the parents and they don't have access to it, then funds will not be available to those programs.
All right. You're still on slide 1. Are we supposed to be moving?
Well, we're moving now. There we go.
No, we're still on slide 1.
Okay. Sorry. I'm not quite sure.
I think you might need to click on when you go back, click on slideshow because it's still on file. It thinks you're trying to save it.
Do you see it now?
Nope.
Lord, can you see it in this view?
Nope.
Okay, let me just pull it up here. Sorry, give me 1 second. Am I still sharing my screen?
Nope.
Okay, well, give me 1 second and then let me just pull it up in this one. Okay. Okay. Can you see it now?
Mm-hmm.
Okay, perfect.
Yep, we can.
Okay. And you can still see it now?
We can. Now we see that in full screen. Now it's moving. Oh boy.
Perfect. So this part is about FERPA. So it's just talking about if any materials or documents include information on more than one student, then the parent has access only to the information about that one student. They can't inspect about the other student at all. The minimum recommendations for a school district to provide this information about FERPA, the law, and the rights to the parents and guardians and eligible students is once a year. And if the parents do not speak English, then it is the district's responsibility to provide that information in their native language. They should also be informed on how to access the educational records. So rights of parents. So the chapter broke it down into different rights. So we have parent rights, non-custodial parent rights, and then you'll have the student rights. So parents have the right to inspect their child's records. They can challenge the accuracy of information. It was suggested that the conference, if they don't agree with something, be scheduled within 10 days or less, but the act says no more than 45 days. If after that conference is scheduled and they talk about it and the parents are still not satisfied, then they can request a hearing with the director over student personnel, and that should be scheduled within 10 days or less. And then the parent can also bring legal counsel. If student records are being requested and consent is needed, then it must be in written form, signed and dated by the person giving consent. The consent form must include the specifics of what records and information that is being released. And then before a judicial order requesting records can be granted, parents, guardians, or eligible students have to be notified. For non-custodial parents, both parents have access to the information unless there's for some reason why they cannot be. But there was a case, I believe it's in New York that the book referred to, that one parent just told the school that they didn't want the ex-husband to have access to the information, the educational record, and the court ruling was that no, that if a parent wants to be involved in their student's educational career or journey, that they have rights to that educational record. And here, rights of eligible students. So students who are 18 years old or enrolled in a post-secondary institution has the same rights as the parents or guardians when they're accessing their student record. The student may decide who has access to the personal files. It can be in addition to the ones that already have access, but they have that choice at that point. The student has the right to have a copy of their file, and then they have the same due process as offered to the parents. They have the right, under certain conditions, to file liability charges for defamation against school personnel. And then the
Let me
right to
ask you
school
a question there. If you have an
Yes,
18-year-old, can they ban their parents from seeing their file?
I would say yes, because they can change it because they're of age. Is that correct?
That is correct.
Okay, so I say
Well,
I thought that that's how I interpret it, but
but
yeah.
now I'm gonna tell you that gets really ugly sometimes. Because what if they don't have the mental capacity to consent?
Hmm.
So here's kind of the litmus test in real life for that one. If the kid is self-contained, you they don't have the mental capacity by law to consent, and so then they can't ban their parent if they're self-contained. If they're just
Okay.
consultative or LD or mainstreamed or whatever, then they would have the right to ban their parents. But you got to be careful on that one. We have any EC people that want to weigh in on that one? That
I
one
was just
gets
gonna
real
say,
sticky.
I don't know a lot about the process, but I know when I've worked with high school students, parents have to retain the rights to, like, so for example, like in the example that you said, if you have a student that's intellectually disabled and doesn't have the capacity to make
Right.
decisions for themselves, the parent has to actually seek out
Yep.
retaining those rights when
Yeah,
it's
and
ready.
they will be granted that. They won't be denied that. Even the kid says they want to. Alicia's, excuse me, Kathleen's exactly right. Kathleen's exactly right. They still have to retain those rights. They have to go back and apply for them under the basis that their child is not intellectually capable of consent. Yep.
Now, Dr. Lamb, what if a child files for emancipation?
If the court grants their emancipation, the parent still has the right until they're 18.
Okay.
That just means they're not under that parent's control, but they would still have the right. Now, the problem comes in if you have an emancipated minor. The problem comes in terms of you can't exclude their parent because they still have parental rights. But then it comes if it comes down to a choice between what the kid said and the parent said, then you get sticky again.
Would
Go
would
ahead.
guardian ad litems be able to have access then to that,
They
or
have to be
no?
they in writing. They have to be granted that in writing. Um, that gives them legal standing. But what they have to understand is that puts them under the same laws and restrictions and responsibility as school personnel when they do that. They can't go out and talk. They can't share. They can't, guardian ad litem. They have to understand that. That they're taking on a in loco parentis role, but they're also taking on a role as the same as a teacher or a school employee, and they would be bound by the same rules of confidentiality. They're supposed to know that, but unfortunately, some of them don't. So to kind of summarize here, if a kid's 18 and he's not intellectually disabled, he can ban his parents from the process and from information. If a guardian ad litem has been duly authorized by either the court or the parents or the person who gives that consent, an 18-year-old can bring a guardian ad litem rather than his parents, but they have to follow the same rules as school personnel. If you have an emancipated minor, that means they're less than 18. Their parents still have access to their records until they're 18. The question becomes, do you go with what the kid says or what the parent says? I have found it safer to go with what the kid said because they are an emancipated minor, but the parent still gets to know what's going on, but they don't get to make the decisions. Basically, that's what emancipation is. The kid gets to make his own decisions. That doesn't mean he's not their child anymore, and it doesn't mean that they don't have rights until he's 18. Gets kind of sticky there, but it's pretty clear. All right, very good.
So the rights of school personnel such as teachers, counselors, and administrators can view the records. When records are accessed by school personnel, they need to be in a written form. Basically, a written form needs to be completed with the date and which records are access. There we go. There's written documentation needs to be kept with the records so that it's available for parents, guardians, and eligible students.
All right, let's stop right there. I believe that was a Meatloaf song. Can you keep a kid's EC file with his cumulative folder file? No. And it happens every day. Every day, especially when they're packing them up to transition the kids like from elementary to middle or middle to high. And guess what? When they arrive to a new place, what do they normally just do? They just normally keep them together, just as a matter of course. They are never supposed to be together. You can get cooked on that one. That's the easy mistake to make. So you need to make sure that your folks in the guidance office are not just putting them together for ease of access. They're supposed to be filed separately. They're not supposed to be together. That's the cumulative folder with the permanent record and then the EC file folder. They are not supposed to be housed together or are part and parcel of one another. And we do it all the time, especially again when we transition kids. But first thing that you need to do is re-separate them and lock them separately when they get to the new school. That's an easy loss in court, by the way.
Oh, sorry.
And by the way, the school gets that fine, not the EC department. The school gets that fine and has to pay it.
Oh. So, school counselors. Some states have passed a law to protect the confidentiality of counselors, but many states have not. North Carolina provides protection for civil and criminal proceedings. South Carolina does not offer protection, which means that a counselor would be required to testify if the court ordered it. Counselors are not required to share information provided by the student to the parents. And records kept by the counselors is not subject to FERPA. If there is a situation that is not in the best interest of the public, then they must disclose and confidentiality does not apply. And I did have a question on that, Dr. Lamb. With the Parent Bill of Rights, does that and the counselors and the information and all of that, does that
Anything
change?
that they've got is subject to that as well. That is correct.
So
But again, their notes should not be either in the EC file or the cum folder, the permanent record. It should be in their separate file. But yes, it is subject to review by parents. That is correct.
Okay.
That's a good point.
And then if there is a situation that is not in the best interest, so the book had mentioned that a student had threatened to kill someone and they ended up doing it and it went to court, and then they found that the counselor could be held with some form of responsibility because they knowingly knew that that was something that was communicated. Yeah.
Yeah, this is not like attorney-client privilege, but even attorney-client privilege, if they have knowledge that a crime may be committed, that privilege does not extend to that anyway. And we won't get into Catholic priest, what goes on in the confessional. That's just for the Catholic Church. In reality, if you have knowledge that a crime or harm may be committed, then yes, you have a duty to report that. That is correct. That is not confidential.
And then digitizing student records, information should be properly collected, entered, and then correctly, and then maintained and kept safe. School leaders must make sure that the platform and hardware that is used is user-friendly, and there is that protection to prevent duplicates being made or unauthorized use. And then enforcement of the state laws and statutes. Federal and state officials may inspect files without parental consent in order to enforce federal or state laws or to audit or evaluate the federal education program. It did, I wrote down on my notes, mention that they don't, I think if I read this correctly, they don't have access to the actual names and that data unless for some reason the court gives them that information, like specific information. And then according to Owasso, I don't know if that's how you pronounce it, peer grading or techniques used by teachers is not prohibited by FERPA. And then FERPA allows for schools to transfer any and all educational records, including disciplinary records. Directory information can be provided to recruiters for the armed forces. And then qualified privilege is when school personnel are protected when a request is made, and then they reply in a reasonable and truthful manner. But this privilege can be revoked if the communication is shared to someone else that doesn't have the best interest or abuses that right. And then that idea of qualified privilege is based on that the educator is operating in good faith. And then, so our policy here that I found with us is that basically parents can go request the records, but they do have to, at our school, they do have like a written thing that they have to like request, and it does get time stamped and dated and all that. But our actual policy here says that it establishes the basic structure for the maintenance of the student records. The principal of each school is the legal custodian of all student records for that school. Students and parents and legal guardians will have access to the students' school records. The following schools will notify parents, legal guardians, and adult students of the following. And it just goes kind of what FERPA and what this chapter mentioned with the records that are kept and the procedures for inspecting and copying these records, and then the right for interpretation. And there's a few more that went with that. But basically, parents can come and request, and they cannot be denied. There is a written track record of when they do come and request it. And then each parent of a child has the right to inspect and review the child's record unless the school district has written evidence that there is a legally binding instrument or a court order governing such matters as divorce, separation, or custody, sorry, which provides to the contrary. The same applies to parental requests for disclosure to other individuals and organizations. And that's it.
All right. Excellent. Now,
sorry, I had one more question, if that's okay, before we move on. There was one part of the chapter that did mention, for instance, something about surveying kids. It said student privacy and physical exams, and it talked about No Child Left Behind had the amendment to the PPRA that gives parents more rights with regard to surveying of minor students, the collection of information from students for marketing purposes, and certain non-emergency medical examinations. Has that changed, or does the North Carolina Bill of Rights, the Parent Bill of Rights, trump that, basically?
The North Carolina Bill of Rights trumps that.
Okay. So do state Bill of Rights always trump federal?
No. But the issue there is the federal government doesn't speak to that, and the state government has filled in that, has claimed that space. And the federal government would have to basically sue the state. It would end up in district court and in a federal court, the Fourth Circuit in Richmond, and it would have to be decided. They have not at this point decided to do that, because the whole emphasis is to, like closing the Department of Education, the federal, is to shift all of these rights to the states. That's the whole impetus of closing the federal Department of Education. They want all these matters to be handled by the state. And the federal government could probably, well, I don't know in this political and climate, but until recently, they could have probably sued the state and won. They chose not to. So the state saw an area where they could step up and make a rule. It doesn't countermand any federal law. It just is in addition to. The feds could say that you've overreached, you've gone too far, and take them to federal court, but that has not happened. There was a lot of folks who thought that would happen with the Parental Bill of Rights in North Carolina. It has not. They weren't monitoring the political climate.
So if you were to violate the Parental Bill of Rights,
Yeah,
but it was still within FERPA,
you'd
then
still
you
be liable in state court.
okay.
Yes, you would still be liable in state. Even though it met the federal guidelines, if it violated the state law, you'd be sued in state court. You'd be charged in state court. That is correct. So you got to make sure that you understand how that works. You have to follow federal law and state law, and sometimes one is more extensive than the other. One kind of picks up where one leaves off, and you can't say, well, I followed this one. You got to follow them both. But I believe there was a time not too long ago where the feds would have stepped in and sued the state and struck down the Family Bill of Rights because it's over too far reaching, but not in this political environment. So it is the law of the land in North Carolina. Very good. All right. Moving on. Alicia's she's going to dig a little deeper into FERPA here.
Yeah. So actually Courtney did a fabulous job. You
Yeah.
can hear a lot of similarities between the two.
Yeah, and so that's why I figured it wouldn't take too long tonight.
Yeah. So you'll kind of hear a lot of the same things. But I'll go through it. I did more kind of the research background of it. Let's see. There we go. So, of course, the question is, what is FERPA? It's also known as the Buckley Amendment. In 1974, Congress passed the Family Educational Rights and Privacy, which is FERPA law, to protect the privacy of students' education records, which, of course, and it kind of talked a little bit about being that it was in 1974 as opposed to nowadays. And so Senator James Buckley actually sponsored the amendment that became FERPA. It gives the parents the right to access their children's educational records, the right to amend the records, and the right to some disclosure of personally identifiable information. When a student does turn 18, the rights transfer from the parent to the student. And I did kind of research, I'll mention that later too, as far as when students actually go off to college. And and the question behind that, because parents paying for college, and so that was kind of a mention of that too, in talking about the Buckley Amendment. FERPA applies to all schools that receive federal funding from the U.S. Department of Ed, and FERPA contains a specific exception that allows schools to use or disclose an education record without the student's consent. So a lot of the things, because we all have to take the test at the beginning of the year, we have to watch the videos, but a lot of the things that I kind of thought I knew, I really didn't, even whenever we got kind of to the military and being at the high school level, as far as with FERPA, what you're allowed to have as far as the access. So the key rights under FERPA, of course, access to records. Parent, student can review educational records at any time. They can request to amend the records if there's an error. Of course, the parent can request the corrections, and that's kind of what my school district mentions within that in a few minutes. Control over disclosure. Schools need consent to release personal data with some exceptions. So as I go through, there's some exceptions to this. There is a right to file complaints. If someone believes that their rights are violated, then complaints can be filed with the Department of Education. What qualifies as educational records? Any record that's really maintained by a school related to a student. That includes, your report cards, your transcripts, discipline records, class schedules, and then you have the health records, which is the other side of it. What are the exceptions to FERPA? Transferring records to other schools, and like a school official also has kind of the exception with the FERPA, but it has to be designated to that. Financial aid is part of that too. That can be the exception. Juvenile justice, if that's very similar at kind of at the high school level that I've kind of dealt with in the past. Legal actions, the health or safety emergency, it did kind of go into some of that situation there where FERPA, there are exceptions to it. And there was actually one with, I think that even Courtney mentioned earlier about the suicide situation. So that's, part of that health and safety emergency. That's when there are exceptions. Directory information, certain things can be out there as far as public information. If a parent does not want their child's name out there, of course, there's certain forms that they can sign. A lot of times what happens with this though is that when parents have that option to opt out, they have to understand that that includes everything. So the child's picture, if they make honor roll, they can't have their picture out there. So that's kind of some of the things that when you talk to parents about the FERPA part of it. This part here, the military recruiters, the military recruiters also have access to the directory. Parents can opt out of this sharing, but a lot of times parents don't even quite realize that until they start getting phone calls from the military, and then they want to know why they're getting phone calls. And so that's the part there that even in my years as an assistant principal, I've started kind of realizing too, as far as what the military is also allowed to have.
All right, let's talk about two things right there. What about the ASVAB? What is the ASVAB?
That is, of course, that's the military test where well, it's not necessarily a military test, but it is. It determines
Yeah,
if
it is.
you're not.
That's the Armed Services test.
Uh-huh.
All right. Can kids be required to take that?
With I'm not really sure. That was the one I was unsure about too. If maybe Kathleen or someone can kind of explain that to us as far as that answer there. That's why I brought in about this military part of it, because I did want to have just kind of a little discussion about it.
Dr. Lamb probably knows. I don't know the answer, but I would assume that the possibility of a draft might influence that requirement. I don't know.
All right. In the era where we don't have selective service, the draft, parents can opt out. If they don't opt out, then everybody takes it. You have to opt out. It's just like the bill. If not disclosed in the directory, parents can opt out. And so everybody takes it unless you have to specifically know to opt out. The problem is we don't tell parents they can. And then we get into the hullabaloo. Parents complain about their kids taking the ASVAB. And then the response is well, you should have opted out. Well, then the parent responds, I didn't know I could. And so that's how that works. Yes, the parent can opt the kid out of taking the ASVAB, but if they don't, then all kids take it. All right, that's the first thing. The second thing is what about ICE, immigration enforcement? Can they come in and ask for records?
I don't.
I would say no.
Yeah, I don't believe they can. I know that this has been a very hot topic recently, though, as far as, but
like
sure
I'm
about that one.
telling the police though, like law enforcement.
Well, even with that
But
too, that's where I'm unsure too, because yes, it does say like, with police with legal situations, but even our like our resource officer, he does not have access to our PowerPoint or our
right.
information about our kids. We have to provide that, whenever there's a
Now,
police
the,
report.
the,
But
the new
but
guy
I'm not.
that's in charge of it for the federal government claims that they do, but it's not been adjudicated in court yet.
Mhm.
I would be careful if I were in a red state. I would be careful not to deny them. I would, if I was principal in a red state, I'd call the superintendent at first thing in the morning and find out what, about that, because that's coming, folks. And I would want to know what the district policy was.
I can tell you,
Or
I
do,
can tell you, Charlotte Mecklenburg's policy is you contact district office right away when anyone
Yep,
comes in asking for any of that.
yep,
Yeah, that's our plan as well.
yep. So I said I'd call first thing in the morning and get clarification,
Mhm.
and then I know that you got to call every time. But I would call ahead of time and say, tell me what I'm going to do when somebody shows up, so that I won't be stumbling around trying to figure it out. But Robert's exactly right. I know what CMS is doing. You got to call in and that, but I would call and get a heads up before it even happened. I'd be proactive on that one.
In Winston,
What's going on in Winston?
the district attorney, she came to the principal and assistant principal meetings and told us about all of those things of what to do. But in the event they come,
Yeah,
and tell them that we have to contact legal first.
right. Yeah, yeah, yeah.
So in the book, it did say that the district complies with before they can comply with the judicial order, that they have to notify the parents. But is ICE technically federal or is it state or
No,
like?
ICE is federal.
So then, would you adhere by the federal for FERPA or would you adhere by the state?
Well, that's what your district has to decide. What hill they want to die on.
Okay.
I mean that's what we're talking about here is if you're in a blue state, it's going to be different than if you're in a red state, even if you're in a blue county in a red state. And that's what Charlotte is. Charlotte is a blue county in a red state. And that's what makes this kind of tricky. Now, if you're in the middle of Iowa, it's pretty simple because there are no blue counties in Iowa. If they're all red counties, all in a red state. They're going to give us unfettered access. They already have. You know what's going on in Iowa. I mean, half of their workforce is not showing up because of this. I don't think, what is it they're talking about? They're going to be, the state's going to be bankrupt in 8 months or something like that. But now they're sticking to their guns. They're giving us unfettered access. Now, in a state like Iowa that's all about agriculture and agricultural related processing, that half of their people are undocumented that work in the fields or in the plants. And they're giving them unfettered access. And so, again, this is that part that's not always clear. But now, if you were the person in the central office that they were calling, you've got to talk to the local district attorney and figure out what will be supported at the local legal level. And that would be a big part of it. So Dr. Hill, I'm sure that she's in touch with the local political and legal machine, so that when Robert calls her, she gives advice based on what she thinks is going to be supported locally. But a lot of this is unclear. But I would want, now Charlotte said they had a meeting. If you've had a meeting, that's what if I was in a district hadn't had a meeting, I'd call in and try to get some information up front. And of course, obviously when they show up, you got to call somebody, but I would want to know what my options were before they showed up, if I could help it. And then if I were sitting in the superintendent's office, I would have already talked to the local folks about what can we support here? What are we willing to support to try to keep my people from getting arrested that work in schools? How far can we go to block these people, or to, on the other hand, how far can we go to assist them if there's going to be, suits coming back the other way?
And I would say, Dr. Lim, in Rowan Salisbury, like we did have a meeting. And of course, like the top priority is definitely to call to the superintendent's office.
Yeah.
They did say that like we can't withhold like information and we can't like lie. So like we can't say a kid is not here. Because by doing that, like we get ourselves locked up as well.
Yeah, exactly. No. No, exactly right. And so what they're telling you is that you will comply, and if you don't, you'll be personally liable, be a tort. Now, Rowan is what? Rowan's a red county in a red state, and they've made that very clear. That's what I'm talking about. It almost goes county by county. But Rowan is a very red county.
Yeah, that is true.
Yeah.
I believe they claim that they have the highest percentage in the state of any county. I've seen that boast from Rowan County that they're the reddest county in the state. So it does not surprise me that they will be completely on board with ICE coming in, and to the point that they've told their people that we will let them get you if you don't assist them. Now, I suspect it might be a little different in Charlotte. But again, it's going to go county by county. Um, but these are the things that you've got to stay in front of.
Hmm.
You've got to know what's going on at the school level, and you've got to be politically aware of that. Superintendent Standard 7, micro political awareness. That's what this class is all about. Um, Again, what did Snoop say? If you don't know, you better ask somebody. Back to Alicia.
Okay. So hold on, I think yeah. Who has access to the records? The parents, until the student turns 18 or enters into the post-secondary. Student, once they turn 18 or enter post-secondary. School officials must have a legitimate educational reason for requesting. And then it also mentioned about certain government officials
Yep.
as well.
That's what we're talking about, certain
Mhm.
government officials.
Um, and then And then as far as my district's policy, there's three parts to it, but basically a student's cumulative education record contains directory information. That's what I was talking about earlier. Scholastic information, standardized test, data, health records, and other similar information. Individual student records are not available for public inspection. However, the Family Educational Rights and Privacy Act, FERPA, affords parents and students over 18 of age, so eligible students, certain rights. So basically kind of summing it up is what the policy has at that point. And then as far as according to Lexington District 2, to inspect and review the student education records, you have within a 45 days of receipt of written request for access. So I think that was very similar to what Courtney mentioned within her district. You have a kind of a time frame. Parents or eligible students should write to the school principal identifying the records they wish to inspect. The principal will make arrangements for access and notify the parent or eligible student of the time and place where the records can be inspected. If it's believed to be inaccurate or misleading, parents or eligible students may ask to amend a record. That's what I mentioned earlier too. So they can ask to amend it. If it did say here, if the district decides not to amend the record as requested by the parent or eligible student, the administration will notify the parent or eligible student of the decision and the right to a hearing regarding of the request of the amendment. With this notification, the district will provide additional information regarding the hearing procedures. So that was a little different too than what I looked at earlier. Again, according to my school district, to consent to disclosure of personally identifiable information containing to the student's records. One exception that permits disclosure without consent is disclosure to a school official with legitimate educational interest, which I mentioned earlier. A school official is a person employed by the district as an administrator, supervisor, instruction, or support staff member, including health or medical staff and law enforcement personnel. A person serving on the school board, a person company with whom the district has contacted to perform a special task, such as an attorney, auditor, medical consultant, or therapist, or a parent or student serving on an official committee. So some of this here, as far as FERPA, and I see what the district is saying as far as it's school officials, but I I do kind of question as far as how far you can take this kind of this statement here. whenever I kind of looked into it, especially when it's kind of it even mentioned about as far as the school board. But I would assume maybe with the school board, if it's a discipline situation where a student's appealing it, is that where that would probably come into line as far as with that?
Yes.
Okay. Okay. So yeah, because I was kind of unsure where that would fit into that too. So that's based on the district. And then I just gave two situational situations here that I found online too, which Courtney kind of mentioned as well earlier. But there's one where it was a 10th grade science class, and the child had just gone through a divorce. And so the mom shows up. She's got the custody, but the father's also asking about the records, and so that's a situation that I know at our school we do deal with a good bit. We'll have a parent say, well, the other parent doesn't have the right to have access, but they do, unless there is a court document that states different than that. So that's I did want to share that one because that's a situational one that we tend to deal with at our school pretty frequent. So just to be kind of aware of that.
All right. The extension of that is contact. Now, that's a different story. Do you allow contact if a parent shows up that's the non-custodial parent? Do you allow them to contact the kid at school or to take the kid away from school?
Not if they're on the list. And then also that's when you contact the parent that is on that list.
That is correct. So the answer is no on both of those unless you have written permission from the custodial parent. That's what I'm talking about. If they just show up and say, I want to have lunch with Johnny. And the answer is no, unless Johnny's mom gives written permission. Or I want to take Johnny to to the fair. No. So it's not just the record. While they can see the record, they can't see the kid. I know that makes no sense, but that's the law. They can still access the record, but if they're non-custodial, they can't access the kid. And so what I've had situations, unfortunately, where schools said, well, that's the non-custodial. They can't see or access the kid, so they can't see or access the record. No, I know that's not consistent, but that's the law.
Dr. Lamb,
Yes.
that has to be proven with a court order, though, right? Like the parent has to bring the court order and put in their records.
Absolutely. And that's what Robert was referring to. And when they do that, you establish a list at that time.
Mm-hmm.
Yeah, that list is the offshoot of that court order. That is correct.
Now, I know that like we had a case where a parent had put in that they didn't want their child to be in contact with the father, and then we found out that we had no custody paperwork.
Well,
we had to check the birth certificate, and it was the father on the birth certificate, so we could not say the parent could not come up and have lunch because there was no court order and the parent was listed.
Well,
but if a parent's not listed on the birth certificate, then I guess would you just have to refer back to that parent if there's no court order, whether the father or the mother? Well, I guess it'd be harder to be
exactly. When we talk about custodial and non-custodial parents, that infers what? Or you are to infer from that, and it implies and you would infer that there is a court order because those are legal terms. Custodial and non-custodial parent is a decree by the court. That's what that means. Those are not just loose terms that we apply to people like Johnny lives with his mama, so she's the custodial parent. No, that's not what that means. Custodial and non-custodial means that there has been a decree by the court. You got to understand that when you say I'm the custodial parent, well, then show me the document that says you are the custodial. That means that you've been to court and there's been a decree by the court, by a judge. That's what that means. So when parents come and say, I'm the custodial parent of Johnny, and then start making demands about access and other things, records and other things, first thing you ask them for is for the court, for the decree from the court. You got to see the paperwork. And then you have to explain to Johnny's mama that even though she might be the custodial parent by court decree, and that the father is not custodial, he still has the right to see the records, not the kid, but the record.
And then I'm guessing I think we had to check the date because we had a parent try to present not updated documents and it had an expiration.
Oh yeah,
on it.
Absolutely. Absolutely. Yeah, you got to keep those things on file and make sure that you know when they expire. They don't last forever. They do not last forever. And so, yeah, you got to go back and double check those things. And so, I mean, I don't know that you need a process in place, but when the father shows up and says, I want to see him, and you know that there's a decree, you go and check it. If it's still in place, then it's a no. If it's expired, then it's a yes. And now the mother's not going to like that, but then I would do a courtesy and call and say, "Father's here to see Johnny. Your consent decree here has expired. Do you have an updated one? If not, then Daddy's going to get to see him, and then Mama's going to come run down there, and there's going to be there's going to be a big knockdown drag out in the lobby of the school, but." Again, we're not always going to have the best situations, but the idea is for you not to get sued and lose your house. You need to follow the law. It won't always make everybody happy, but you need to protect yourself. I think Alicia even said that in one of her responses.
Yeah,
I'm figuring out. Maybe I didn't know these policies as well as I did, and it's not for the point of enforcing them, but it's to keep myself safe. That's why we need to know the policies and the laws, is to keep from losing our house first. I know that sounds very mercenary, but you can't do anybody any good if you're living out of your car, folks. So a word to the wise, you don't want to lose your house. So that's what we're talking about here, is how do you act every day? How do you comport yourself so that you stay within the law and don't end up losing when you go to court? Now, I can't keep you from getting sued, but the idea is to keep from losing. All right, that's a good scenario there. I like that one. That has a lot of good pieces that we can kind of dig into and talk about scenarios. All right, what's the next one?
And then the next one, this was one that Courtney mentioned earlier too. And this was where talking about being able to grade other students' work. With this situation here, I was talking about a local middle school. They were doing a pretest, and the students swapped papers and graded each other's work, and it said that was not violating FERPA. So that and that's the one where because we've had some situations similar to this, that we had a teacher who had other kids grading other kids' work, and then it was a discussion about it, if that's a FERPA violation or not. So that's why I did want to bring that situation up too, as I looked at that one.
Well, that calls into mind for me the question is that a sound educational practice?
Yeah. Well, and that's kind of how we approached it, but actually what was interesting is that the teacher brought this situation up. So
Yeah.
this particular case here. So it was of course then my principal didn't like that response either, but it was that's what's been interesting about researching the FERPA kind of in more detail and looking at the different situational, these two scenarios here, is that because these are things that have happened, and what exactly is the answer. So,
Mhm.
and then that's it. Those are the references from the information that I got.
Excellent. All right.
And
That's very good presentations tonight. I have one thing I want to talk about. And this is kind of a discussion question. What is an educational record? When we saw it defined tonight, but what is an educational record? So, one of the fellows that used to work with me, he's since left the school system and he works for a private group now. I think he works for Curriculum Associates. He's one of those guys that travels around. He's a MTSS EC expert. He was EC director, I think, in Lincoln County when I hired him to work with us at Gardner Webb. And he's really sharp, really, really. That's why Curriculum Associates is making him a millionaire. He's flying all over the country now. But I haven't talked to him recently. I don't know if his lawsuit's been settled or not or what has happened, but he was sued as principal. Before he went to the central office, he was a principal. And two of his, you know what happens when bell rings in elementary or middle school? All the teachers go to the hallway and monitor the class movement. And two teachers were talking, their doors were nearby, and they were talking about a child. A third teacher overheard them and reported their ex parte conversation to that child's mother, and she sued because he was an EC kid. And the parent is claiming that anything pertaining to that child, because he's EC, is an educational record and are claiming a FERPA violation. What do you think about that?
I don't know if I agree with it fully, but I don't disagree because I have been privy to a lot of conversations that are inappropriate in front of other students. The chit chat between teachers
Yep.
sometimes is not supposed to be had in front of people that are not part of that student's education.
Yeah. Yeah. And so I don't know how that case has been resolved. It was to go to trial. They found that, it wasn't dismissed at the lower level, and so it did go. My point is, most anything can be construed. I mean, anybody can be sued for anything, and most anything could be argued to be an educational record. And so what we really have to talk to our teachers about is not be having conversations about kids in public spaces. All right. Now, this one happened to me years and years and years ago. I was in the central office and I was supervising a school, and I was in the lobby waiting on the principal when right off the lobby was the teacher's lounge. And I heard teacher assistants discussing kids in the lounge, and I could hear it into the lobby where there were other people coming in and workmen and delivery and other parents and those kinds of things were in the lobby there, and we could hear into there, and we could hear these teacher assistants talking about children, most specifically about their behavior. Would that be an educational record? I believe that it would be. And what made it even more so was this was a public separate school. This was an EC school. All the kids in the school were EC. And so my contention is they ought to, in a school where every kid's EC, how could you not know that you shouldn't be talking about any of these kids? And so loose lips sink ships. It's hard enough to navigate all the laws, the different, the different warring factions politically, ICE, the police, all these things. Those things sometimes are beyond your control. My argument tonight is the thing, control what you can, which is how your faculties, how your staffs operate at the school level. You have some control over that. And again, most anything can be argued to be an educational record. And so why else would you be talking about a kid in an educational environment? And that's what got that one to the court case that has gone to court. And the one that I was talking about is why would you be talking about a kid other than his educational record in a school? And that was the basis of how that one proceeded to the actual trial. So again, you need to be careful. You need to have everybody, bus drivers, lunchroom, cafeteria workers, teacher assistants. It doesn't matter. Everybody needs to know the rules on FERPA. Everybody needs to know that you can't discuss a kid's educational record and anything in the context. If he's in the building and you're talking about him, then that could be construed as an educational record. That's one you need to be very careful with. All right. Amanda, you want to go tonight?
I can.
Go. There we go.
Okay. Alrighty. So I had chapter 10, which is recruitment, tenure, dismissal, and due process. Okay. So the first thing that I wanted to talk about, the major topic, was the recruitment of personnel. So in this chapter, it discussed a lot about different ways for recruitment across the nation. And it said that many districts commonly create incentives to attract the best personnel. And a lot of the incentives that they used across the nation were low interest mortgages, forgiveness of college loans, discounts on certain purchases, and signing bonuses. And
What do
then
those all have in common?
money.
Yeah, money, but it's also none of them are salary and none of them are ongoing or recurring.
Right.
And so one of the things that, what actually works is to raise people's salary because they get it, that's an ongoing thing. A lot of these, while they're good, we're finding out that they don't, like a signing bonus, that's one time. College loan forgiveness, um, all of these have an end date on them. And if you truly want to recruit, attract, and recruit, you have to pay more and not just one time, is my point. The one time we're finding out doesn't work real well.
No, exactly. And so then they also talked about in the chapter, in this section, to always make sure that you have a positive impression on candidates at the school and the district level interviews, to also make sure that they have that positive, uh, the positive with the ongoing process, onboarding process as well. So that it went through the recruitment of interviews. And then they made sure that you have to be careful with certain personnel interviews that are illegal and that can get you in trouble. So the personnel interviews must be very specific, but then you can have open-ended question that the candidate can lead themselves to offering up information on their own without you prompting them to. So my next major topic that was in there was the tenure topic. So we have discussed this, that tenure provides teachers protection and for the due process rights before any firing may happen. So within this, it also talked about having the fixed term contracts for principals to appear to have them have a degree of protection. And then it also gave them a way to be protected under the due process as well hearings, just in case that their contract was canceled prior to the contract expiration date. So it did say in the chapter that fixed term contracts are becoming more and more popular throughout the nation. Then I found it interesting that only 13 states provided some type of tenure. So these first states, they give a very strong tenure, which is Hawaii, Montana, Pennsylvania, New York, and Washington. Um, and then it gave to the next strongest was West Virginia, Minnesota, Alabama. The next group is average group, and that is the North Dakota, Nebraska, Iowa, and New Hampshire. And then Utah actually fell into the weak tenure contracts. But these were those states that were listed on there. Um, Major topic number 3 was the dismissal. So it went through very much in depth if you guys want to read that part of it. But the major parts of dismissal to make sure that you are up on policies and laws. Incompetency, obviously, it's in its name. So just making sure that you are recording observations to give proof if the teachers are unable to give the content. Then you have insubordination. So it's just following that fair treatment, just making sure that terminology does vary among states, but its most common definition is just failure to follow reasonable and valid administration. Then it's the neglect of duty. So obviously the failure to carry out professional responsibilities or your performance. The just cause is very broad and is used a lot because it kind of falls, it's a giant umbrella and falls for a lot of termination rulings. Teacher misconduct is investigated and documented with specific facts, and just make sure that you have witnesses as well. In the chapter, it gave 7 steps to make sure that you followed everything of part of the investigation, part of the documentation, and what the witnesses have to do and partake in. So then there was also immortality. So just making sure that they're just an unfit teacher. There was the homosexuality and employment in public schools. There is a private acts versus the public acts. And previously we talked about the Tinker case, as well as there's the National Gay Rights Task Force. Then you can have the conduct involving morality. So that is viewed as like you're viewed as this exemplar person out in public. So like you can't be at the grocery store having a whole cart of wine bottles. You better push that cart down another aisle. So again, it goes through all of these things that you are that exemplary model. Your dress, how you look, your morale, your social behaviors in public, your marital status, the sex orientation, sex acts, and if you use profanity. So then the criminal activity. So again, obviously, if you have a felony record, you're under any influence of drugs or alcohol. There is the sexual advance towards students. In this part, I found it very shocking that this case, Doe versus Taylor, everybody knew it was reported, the student reported it. Other students reported it, the parents reported it, the principal reported it to the superintendent, and the superintendent put it back on the principal to investigate. And the only person who had immunity was the superintendent. And then my last one
That's why
down
you hear me
here.
say all the time, call the law.
Yeah.
You are not qualified to do investigations of a sexual nature. The superintendent has immunity. You do not, as at the school level. You better involve
Mhm.
the police because that's what the law is, that you report these things. It goes back to that disciplinary data handbook. It talks about all the things you have to report to law enforcement. That's what I'm talking about. You have to do that, and don't say, well, they'll be mad at me at the central office because it'll be a bad PR. No, again. Superintendent has immunity. You do not. So you got to report. Now, before we move to the next one, if you had a teacher that violated FERPA and was talking about kids and their educational record out in public, which of these statutes could you dismiss them with?
Just dismiss them based on, I
On
mean,
that.
multiple things. I would put on the neglect of their
Neglect
duty.
of duty
Like,
is the one. That would be the one.
okay. Is there multiple ones? Because that's what I was thinking, that there could have been multiple.
You could, let me pour this right quick. You could,
Because
but
I would think that the other, I guess, misconduct is a little bit
it's too
more,
broad.
yeah.
Failure to carry out
Okay.
professional responsibilities. That's exactly what FERPA. FERPA is a law, and teachers have to follow the law. And so that one you can get them on. If you try it on
Okay.
something else, you then you have to prove, like insubordination, you have to prove that you already told them to quit it, not to do it.
Right.
Specifically, you can't just say, "Well, I had a workshop." Incompetency is hard to prove. Um, Misconduct, they would say, "I didn't know that." That misconduct means um, means that you and that shows intent. Neglect of duty, failure to carry out professional responsibilities. There's that one is clear cut. That one you don't have to argue that they should or shouldn't have done this, because the law is clear on that one. So that's the one you would use, neglect of duty.
Okay.
All right.
Real quick, I do have a question
Yeah.
about that, about this overall, because some similar situations, but like the FMLA,
Mhm.
I mean, with that, I know it's because it's FMLA, but it's still a neglect of duty because the performance is, they're not at school. So that's, I'm still confused with the FMLA, how, with a teacher who's doing that, but yet they're
Basically,
not
what
having, they're
FMLA
not there.
does is just pauses everything. It's just a pause. If you have a teacher that's in some kind of a disciplinary process that doesn't stop it, it's
Mhm.
just paused during that time, and when they come back, it resumes.
Mhm.
Well, and we have like intermittent FMLA where a
Yeah.
teacher can come when they can and not, but it's so that's where it's been really tricky here with this trying to figure out dismissal.
You need better policies on what qualifies as FMLA.
Mm-hmm. Yeah, that's what I was when I was looking at our policy overall too. So yeah.
Mhm.
Yeah, you need to tighten that policy up if they're
Mhm.
using that as a get out of jail free card.
Mm-hmm.
And that's and people do that, yes.
Mm-hmm.
Um, and so, but in the end, it's only going to prolong the inevitable. You don't have to start all over again. You pick right up. It's just a pause. Legally, they say, well, I was out for this much time. Yeah, but we just pick right back up. We don't have to go back to the beginning and start again. It's a pause. So it might take longer, but but again, that's based on if you tightened your policy up, you could get around that as well. But even if you didn't, it eventually you can move against these people. It's not like a get out of jail free card, but I know, yes, some people do that. Now, um, on the Family Medical Leave Act, um, I think it's been defined too broadly, and people didn't read the actual act itself, and they're granting some things that they don't have to. They don't have to. And so that's where districts that's on them, that they need to do a better job. They're defining too broadly. Um, and they're being too timid in the enforcement piece.
And I think that's kind of where my district is
Yep.
they immediately say, well, I mean, it'll be a lawsuit. We don't want a lawsuit. I'm going, well, we're hurting kids in the process, so it's
Yeah,
not,
exactly.
we're worse off this way. So
Yeah.
I was just wondering if that's
Yeah, I
going
mean,
into the neglect
I
of
mean,
duty.
they're just using that. They're just using FMLA as an excuse not to go to court.
Mm-hmm.
And if you're not willing to go to court, you can't really run a school district. You're gonna have to go.
Mm-hmm.
Again, I told you I can't. You're gonna have to go. Just don't want to lose.
Mm-hmm.
But you can't be afraid of going.
Yeah.
Very good.
The last one on here is actually out of the teacher's hands. It just really is just diminishing positions at the school level or at the district level. And it just lists a bunch of different ones. I guess there was like a reduction in the budget or any financial problems that they would have to get rid of a position. Topic number 4, they discuss Fair Labor Standard Acts and the right to work. So then this was very interesting to me, and I'll get to it at the end of like what I learned on this as well. So the right to work obviously just emerged after the National Labor Act in 1935, and the right to work laws tend to weaker labor unions. And then the basic intent of the law is just to ensure that any non-exempt employees receive fair treatment, and appropriate compensation for performing their assigned duties. And then the non-exempt employees that include any of the clerical personnel, the food service personnel, the custodial staff, campus security, any of those add-on workers. So what was new to me was this collective bargaining. So it's popular within the union state. So it's many educators view it as like a mechanism to achieve a greater role in management and operation of public schools. And then it did discuss private sectors, so private schools versus public sectors. And in the public sector, bargaining of employees is afforded equal protection rights under due process that we have talked about before. So just making sure that they're following the Fifth and 14th Amendment to help with those bargaining. So within the private sector, it was restructured in 1947 with the National Labor Relations Act. Then there was a union corruption, of course. Someone was making money off of something. Then it was turned to Labor Management Relations Act or Taft-Hartley Act, and then later again revised to the Labor Management Reporting and Disclosure Act in 1959. Topic 5 was teacher strikes. So in the private sector, rejection of an offer is most often followed by a strike when there is an impasse occurring. So again, it talked about within this chapter across the nation that there are many teacher strikes, but you definitely need to make sure you know your policies and you know the laws of where you're at because it is different from all over. So again, it's all that a disagreement hasn't occurred, but in this chapter they kept calling it the impasse. So then in states where strikes are not permitted by law, penalties are imposed on teachers and union officials. So which may range from loss of salary to dismissal for teachers, and very stiff fines within there. And it actually was giving their salary as their fine. And then a number of states that have passed permissive litigation to aid recognized union organizations. So it listed 3 different types. So you can have an agency shop, you can have the union shop, or you can have a closed shop. Then there is the following, there's 13 states that permit strikes. So you have to follow certain conditions and steps when any negotiation is an agreement. And they're pretty detailed to make sure that you follow each of these in these 13 states. Where there are no strike laws are within our state, Georgia and Tennessee. And then there are illegal strikes in certain districts. Oops, sorry, my assistant here. Turn the page. Illegal strikes in districts in Indiana, Michigan, and Massachusetts. So they actually pay a set fine each day they are gone on strike. Eleanor, what did you do? Sorry. Okay, let's see that. Oh, good. Okay, so lessons I've learned. So again, going back to that private versus public sector bargaining, I did not know this until I was in CMS first, then stayed home, and then I went to a charter school, which I did bargain my salary. So I was a different pay than a lot of teachers that were on the same teaching year that I was on. And then coming to the public back into CMS, I had to go on their set pay salary and I couldn't bargain of what I was paying. So again, there are state laws vary regarding issues that you can't deem negotiable. So there are mandatory and it must involve both parties, the ones who are being hired and the board. Then there is the permissive bargaining, and that's just coming to a common agreement. So like the personnel recruitment, the selection, and the induction. There is a bargaining where there's neither. So negotiations between the teacher union and the board of education. Um, those are just that are set in stone, basically with unions that you can't touch. I'm sorry, that you cannot with planning periods, the change of length of class periods, non-teaching assignments, your sick leave days that you earn, and then any academic policies. Then there's the marginal the bargaining that you can't the academic standards you have to teach, any personnel matters, the organizational structure, budgeting is non-negotiable, and then the technology if there's any incentives to give more. Then the other thing that I learned was the collective bargaining. And again, within the public schools. So a lot of the topics that it talked about was the right to strike, the preferential status of the exclusive bargaining, then the preferential treatment in any layoffs, definitely having the free speech rights for teachers that are not union, and then any good faith negotiations. So at my charter school during COVID, they placed a policy that you had to be vaccinated in order to teach there. So that we lost actually our whole EC department, and it was on the news and it was brought out, and a lot of the teachers that were vaccinated joined the parents and EC staff on our campus that were just holding up signs and everything. And if the teachers did not take off, they were actually dismissed for that. And then just talking about the differences of the impasse is that you go through mediation. After mediation and nothing gets resolved, then you go to a fact finder, and a fact finder is that just a person who goes through all the facts and analyzes everything. And then in the end is that binding document that you cannot go back off of or change in that bargaining. So implications as me as a teacher, I'm interconnected as an employer, as tenure and due process. At Myers Park Traditional, they have a hiring team, and it is everybody from the whole entire department in the school. And there's a scripted questionnaire from the district as well, and the schools. And then when members of the staff with their let go, we just had a teacher let go, and our principal did an immediate morning meeting to share with us to basically just say to not do the gossip. And obviously making sure none of important information is shared. That's not allowed. And then in Charlotte-Mecklenburg schools, they offer incentives for recruitments. I do believe for more of beginning teachers than any other teachers moving districts. And then questions in chapter 10 that were listed was just how you get tenure, how you lose it, the legal references, and then policies. So in the chapter, they gave this really nice table that gave legal requirements on there and list everything for it. And then my next two slides were all the policies for everything listed in there.
All righty. We're going to go over that one more when we're together next. We're going to go through that because, as many of you know, North and South Carolina are right to work states, no unions, can't strike. All those things can't, as Amanda said, public school teachers can't negotiate. Charter schools being kind of in the gray, considered private for most, you can. But we're gonna walk through a lot of those differences and what rights teachers have and don't have. We're going to spend a little time on that when we're together next. I wanted her to get this one out tonight because we don't meet again before we get together. I want y'all to see that and work on, try to find out how it works where you are. And we'll talk about the difference between charters and privates, North and South Carolina. But it's good to know a lot of these things, even though it may not be applicable to where you are now. That doesn't mean that you won't eventually be somewhere, and you need to have a wide knowledge base, as Amanda presented tonight. She presented, like she said, these are options. You don't know you have that because we don't have them in this state. That doesn't mean they don't exist. And if you move states, you're going to find out that things vary very much. And that's great job tonight, Amanda. That's one of the things we need to know is everything's not always the same just where you are right now. And if you aren't always there, things will change. And you need to be abreast of these things. And you need to understand what due process is in your district. All right. Anybody have anything else for the good of the group tonight? All right. I'll get so we're going to have biscuits on Saturday, according to my calendar, on Saturday the 29th. And so I'll send you a link to put your order in. All righty. That's important stuff. Got to get fed here. All right. Anybody else have anything else? Work on your dissertation. Get in touch with me. Carter, I'll see you tomorrow night. All right. Everybody have a good week. I'll see you at the end of the month. Thank you again.
Bye-bye.